Ignoring your ex's family law court application won't make it go away. In this video, I'm going to give you a case summary of a 2021 case called Averill and Averill. So this was a property matter, it wasn't a parenting matter. And in this case, it had actually been listed for an undefended hearing. So basically, the husband hadn't engaged and the matter just progressed in court without him. Now, on the date that it was listed for an undefended hearing, where the wife was essentially asking the court to make orders in his absence, he showed up and he wanted to be involved to a degree. As a family law practitioner, I see it very often that a party won't engage. They'll ignore all correspondence and they'll ignore the court application until it gets to the point where it's been listed for an undefended hearing or for something that they consider more serious. And then they show up and they want to be heard. Start from the beginning and see what the court did in this matter. This is a citation and you can view the entire judgment for free using Ostley. So this matter was heard in Sydney. The parties commenced cohabitation, so they started living together in about 2008. They married in 2010, separated under one roof from 2 December 2018, and then the husband vacated the former matrimonial home on 26 January 2019. There were 2 children of the relationship, one born in 2011 and one born in 2013. As I said, parenting wasn't an issue in this case, but the evidence accepted was that the children lived with the wife, the mother, and spent 5 nights a fortnight with the husband. The wife commenced property proceedings in November 2019, and the husband repeatedly failed to comply with directions and to file responsive material. The matter was listed for an undefended hearing with express orders and notations warning that the hearing would proceed undefended even if the husband appeared, unless he filed material by the ordered deadline. Shortly before the final hearing, the husband, who was then at the time represented by a solicitor, sought an adjournment, asserting mental health difficulties had prevented participation. The wife sought final property orders, including transfer of the former matrimonial home to her, a super split, closure of joint accounts, and related injunctive trustee orders. So the issues that the court had to consider were: 1, whether the husband had established a sufficient basis for an adjournment of an undefended hearing, including whether procedural fairness required an adjournment given his asserted mental health difficulties. 2, whether it was just and equitable to make property adjustment orders pursuant to Section 79 of the Family Law Act. 3, identification and valuation of the property pool, including treatment of a proposed add-back where the value was unknown. 4, assessment of contributions and any adjustment for future needs, commonly referred to today post-amendment as current and future circumstances adjustment. 5, what final property orders were appropriate. And 6, costs were raised but not determined in the published reasons. All right, so the court accepted the wife had complied with service requirements and found the husband had been given more than adequate notice of the listing and the consequences of non-compliance. The court applied principles concerning proceeding in the absence of a party and the requirement that procedural fairness is satisfied by providing a proper opportunity to participate, not unlimited opportunities. Authorities referred to include cases such as Talbot and Talbot. The husband's evidence relied on asserted depressive symptoms said to have prevented him from engaging with the proceedings. The GP letter dated 5 November 2020 recorded a consultation on the 13th of February 2019 and stated that the husband had adjusted and had no current depressive or anxiety symptoms. The court found the medical material did not support an incapacity to participate through the relevant period, particularly given the husband's earlier appearances in March 2020. The court did not accept that the husband had established incapacity to participate due to mental health. Prejudice to the wife from further delay and costs and prejudice to other litigants and the court's resources were taken into account, and the adjournment application was dismissed. Essentially, the court said you had your opportunity to engage and do what was required and you didn't take it. We don't accept your medical evidence. We're proceeding on an undefended basis. Move on to talk about the actual property settlement now. That was determined on an undefended basis. The court identified the property pool largely on the wife's uncontested evidence, made findings on specific valuations where evidence permitted, and declined to include items where there was insufficient evidence. The former matrimonial home was valued at $3.4 million, accepting a real estate market appraisal at the lower end of the indicated range as the only valuation evidence available. Loan from the wife's mother under a deed of loan connected to the property purchase, treated as a joint liability and valued at $2,958,000. A further loan from the wife's mother to meet mortgage arrears, treated as a joint liability of $18,853. One motor vehicle valued at $5,000. The husband's cash at bank excluded due to insufficient evidence. Proposed add back for sale of motor vehicle 2 not included because the sale was established, but the value of the proceeds was not. Based on these findings, the court recorded a net pool excluding super of negative $33,031 and a net pool including super of $103,420. Contributions were assessed overall at 55% to the wife and 45% to the husband. A further adjustment, so a current and future circumstances adjustment, previously referred to future needs adjustment, of 10% was made in favour of the wife. And the future needs adjustment was made primarily due to her lower earning capacity and the primary care of the children. The final percentage division was 65% to the wife and 35% to the husband. I'll just briefly touch on the orders that were made. So the court made orders that the applicant wife retain 73.92% of the husband's superannuation interest. The former family home, the primary residence, was to be transferred from joint names to the wife. She was to refinance the mortgage. The respondent husband was restrained by injunction from redrawing any funds from the National Australia bank account, which was in the parties' joint names. And that pursuant to Section 106A of the Family Law Act, the applicant wife was appointed as the trustee for the respondent husband to do all acts and things to close all of the joint accounts, and they've listed several joint accounts. The respondent husband was ordered to make available for the applicant wife's collection the motor vehicle 1 registered in his name. He was ordered to transfer to the wife his whole right, title and interest in that motor vehicle. There was a standard order that, subject to these orders, the applicant wife be entitled to the exclusion of the respondent husband to all property, both real and personal, in her ownership, possession and control now and in the future, but not limited to monies held in financial institutions in her name, all insurance policies in her name, motor vehicles registered in her name, and her entitlements in any superannuation fund. There was an order that the respondent husband indemnify and keep indemnified the applicant wife from and in respect of any actions, claims, suits and demands as may be made against the applicant wife in relation to any liabilities in the name of the respondent husband and any other liabilities in relation to any property that vests with the respondent husband pursuant to the orders. Similarly, the applicant wife was ordered to indemnify and keep indemnified the respondent husband from and in respect of any action, claims, suits and demands as may be made against the respondent husband in relation to all liabilities arising under the specific loan agreement dated 3 December 2013, any liabilities in her name, any other liabilities in relation to any other property that vests with the wife pursuant to the orders. It's interesting, there's a section of the Family Law Act I mentioned before, Section 106A. Often the court or people, when they're doing consent orders, will pop a 106A order in, which empowers a registrar of the court to sign documents if a party is anticipated that they're not going to sign documents. They might hold things up. And what happens is, say you're trying to sell a house and the other party just won't sign documents. If they're breaching the orders, you can provide evidence of the breach to the court, and then the registrar can sign documents on behalf of the person who is refusing to sign and breaching the orders. A 106A order was ordered in this case. It reads as follows: in default of the respondent husband doing all acts and things and executing all such documents as are necessary to give effect to these orders within the time period stipulated, a registrar of the Federal Circuit and Family Court of Australia at Sydney be appointed pursuant to Section 106A of the Family Law Act to execute all such documents in the name of the respondent husband and to do all acts and things necessary to give validity to the operation of the said orders. So that's a good provision to keep up your sleeve if you're trying to craft orders and you're concerned that the other party won't sign documents. Yes, in this matter, it proceeded on an undefended basis without submissions or evidence from the husband. So as I said at the beginning of this video, burying your head in the sand, ignoring the court application, ignoring genuine attempts to negotiate and settle the matter can backfire, as happened in this case. As always, the content of this video doesn't include legal advice. It contains a single case summary. Stay tuned for more Australian family law case summaries.